Oftentimes it can be death, suicidal ideation, headaches, trouble breathing. There are lots of different things. I'm not talking about the specific medication right now, but there are a lot of things that you can pull up related to from the website of that uh, manufacturer of that medication that will show you what the warnings are related to having to end medication. So I would suggest if you're talking about a medical expedite that you not just say, again, not legal advice, but as an attorney, what we're often looking at is we're trying not to just say this person needs this type of medication for diabetes or for blood pressure or for cholesterol or for anxiety, but the consequences of losing that medication would have severe, even potential death consequences to the person if they can't access it anymore. In order to do an expedite request, you're typically going to need to call USCIS and put in the request. And then they'll usually give you an opportunity to mail in the related documentation for the medical expedite. If you don't have any documentation to send them, not a bill, not a receipt, no pill bottles, no letter from a doctor or a clinician, it's really hard to get the medical expedite to go through. There's usually communication that happens related to emailing or mailing in that supporting documentation. Just depends on what customer service is requesting that day. And then eventually you'll hear back related to it. And of course, for those of you who are doing online filings, then there may be uploads and uploaded notifications there with your final answer. So if the medical expedite is not immediately successful, you can simultaneously pursue congressional liaison requests. So regardless of political affiliation, each senator and House of Representatives in the federal government, those representatives, your congressional representatives, have a constituents assistance program. And regardless of your inability to vote as a DACA holder, you're still a constituent that those senators or representatives cover. So there's a Privacy Act release form that needs to get filled out and signed by you. You want to make sure that you're the one signing it. It cannot be just passed off to someone else to sign for you. If signatures don't match up, then there's going to be an issue with processing your request. But the Privacy Act release form is about giving permission to the senator's office, for example, to communicate with USCIS on your behalf related to the expedite request. If you don't sign that form, they cannot communicate with USCIS for you, and your congressional request will go nowhere. When you sign that form and you're emailing back and forth with your congressional representative about this, again, you're going to want to focus typically where possible on your medical expedite. You can also add in hardship. You can give more than one explanation as to why you need the expedite. And then hopefully you will hear back, but it is nothing fast. The expedites are not things that typically happen overnight. Most of the time you could still be waiting a month before, and there could be weeks of back and forth before you get something back from USCIS on it. So if you don't have a decision on your DACA renewal and your status is about to expire in a month or less, and you haven't tried an expedite and think you were qualifying for one, it's time to probably move forward with that. Another tip, please, if you have an immigration attorney handling your DACA, don't go do expedite requests on your own pro se without your lawyer's knowledge. You can really screw up your case by double dipping into systems, sending incorrect information, going behind your lawyer's back, essentially, and sending in documentation to the Immigration Service that they have not reviewed or have no knowledge of. So it really should be a collaboration between the DACA client and their law firm that is representing them to submit any expedite requests. I cannot tell you how many times I have seen clients send us information they think will qualify for an expedite request, and it's not our client's fault, but it's poorly written. It doesn't even really explain what is needed for the expedite. It doesn't match the very specific buzzwords or criteria that USCIS needs to hear. So, with accurate information, with truthful information, and qualifying for an expedite, you have a better chance of getting it granted. If you haven't been clear, you don't have backup documentation, it's poorly explained, then you're less likely to be successful with an expedite.